Good afternoon, everyone. At the outset, on the behalf of the Institute of Company Secretaries of India, I most sincerely, very warmly welcome our distinguished learned speaker, Sri Atul Mittalji, a former Central Council member, a professional par excellence. I must say, very thorough professional indeed. Atulji, we welcome you very warmly, very sincerely to this live webinar organized by the Institute of Company Secretaries of India. It is for the accomplishment of our mission to develop a high caliber professional facilitating good corporate governance that the ICSI is constantly launching initiative placing greater focus on continuous learning curve, learning development. And in its endeavor only, the CLDC committee of the ICSI proposed to organize the Master Knowledge Series, Triple E series this season only, and it was approved by our honorable president Sri Manish Gupta ji, and then it was launched at PCS conference Vizag on 17th of June. And accordingly, we are here with this live webinar on the finer nuances of the FEMA. And I think that there could not have been better speaker than you. We know that how much you have been propagating the FEMA compliances as professional for the last 20-25 years. And whenever any name comes in mind, so far as FEMA compliance is concerned, a very seasoned professional, a very thorough professional like you only come to my mind, to our mind. And I'm truly delighted to welcome all the participants of this webinar, all the senior members, all the young members, all the members of the managing committee of the chapters, members of the regional council. I also extend my warm welcome to you, Atul Bhai, once again. Our president, Sri Manish Gupta, was supposed to join, but since he has been traveling, he was not able to join this webinar, but he has sent his good wishes. And I'm sure with his good wishes, we will be able to take it forward to a logical conclusion. During next 7 months, starting today till 18th of January 2024, our endeavor is to organize as many webinars as could be possible. Normally, what we have planned is that we will be organizing a webinar from 3 to 5 every Wednesday, and we will be inviting only very seasoned and experienced faculty like Atul Bhai. So, Atul Bhai, coming to the topic of the today, I feel that understanding the growing global role of the governance professional, it was thought fit to begin this series with focus on the finer nuances of the law under FEMA only, because it connects us with the world that lies beyond the territorial boundaries of the country. And as I said, the topic is finer nuances of the FEMA, and we tend to focus today on the inbound, outbound investment and contravention and compounding. So over to you, Atul Bhai. I before I hand over to you, I also acknowledge the presence of CS Deepa Khatri ji, who is leading our CLDC secretariat, and see the person behind all these arrangements and all these nitties and gritties of organizing this seminar, and see the lady who would be coordinating with all the speaker in times to come and also planning all the webinars. So I welcome you, Deepa ji. And I also extend my warm welcome to the your secretariat, and I also appreciate the hard work put in by you. So Atul Bhai, over to you now, and I'm sure that with your knowledge, with your enriched experience, all the participants of this webinar will be hugely benefited. Thank you so much. Your voice is not audible, Atul Bhai. You are muted.
Thank you very much, my past council colleague, Dhananjay Shukla, and my friend, more than that, and Deepa. But during my council days, Deepa was one of the team members who was always proactive when it comes to the academic part. And particularly, I still remember, Deepa, when you were spending time, lots of time in the Ministry of Corporate Affairs when this company secretary's appointment and other stuff was taking place. And lots of support you have expended. Dhananjay's sweet memories are there when we were together in the council for sure,
Yes.
And thereafter a number of other occasions, not only the regional council, then Gurgaon chapter council and other stuff. We still remember. Thank you very much for giving me this opportunity once again to interact with my own family members on a topic which is always, I would say, apt to my. They think, look, for Foreign Exchange Management Act, be it is a Foreign Exchange Regulation Act, and so on and so forth. I always used to say, I'm sure for the sake of repetition, I can say, always, this topic is close to my heart. Since my student days studentship days, when I started my studentship days since 1995 from 1996 when I qualified, till that, from those days till date, I think one of the act or very, very small act consisting of only 47 section is keeping me alive, not only in profession, but in my personal life as well. When it comes to, surviving, earning and surviving, this is one of the area, one of the topic which I believe most of my career is been passed from working and particularly advising my client and my promoters whenever all management till the time I was in industry. Thereafter, I joined consulting, Pricewaterhouse and Deloitte, etc. I think this is one of the area I believe which is always close because of the fundamental fact. See, we are living in a scenario when we all of us look for a globalization and multinational. And when we talk about the globalization and multinational scenario, of course, always comes to our mind inbound and outbound investment, trade transaction, and whatever is taking place, inflow and outflow of foreign exchange from the perspective of trade and investment. What are the rules and regulation governing those things? What are the procedural part? And what are the nuances we have to keep in mind so that if anything comes later on which surfaces outlook, yes, there were certain gaps which was supposed to be adhered to, has not been done so. What are the immunity available to us? What are the chances of getting rid of it by way of imposition of a penalty, levy of the penalty by the authority like Reserve Bank of India? Even if, not only that, even if a scenario comes when Reserve Bank of India is also not been in a position to settle it down, and when it been transferred, so the matter of this so-called gaps in compliances or contravention or non-compliance is being transferred or referred to the investigating authority, which is nowadays, I think every kid must be naming one agency is called Enforcement Directorate, Department for Investment. Whenever such kind of matters are being referred to, how we need to deal with that. I would request, though I will try my level best to cover, and wherever required, I will say, look, these are the area we have to keep in mind, but I would request to the audience also, or to Dhananjay bhai, to you also, to keep me reminding what are the things we have to keep in mind, not only from the perspective of practice, from our practicing professional, but also whenever they're advising, being an in-house counsel or in-house company secretary, what are the things they have to keep in mind, particularly dealing with this? Because nowadays you must have seen day by day, cases of the contravention and non-compliances are increasing, particularly with the Enforcement Directorate office. How we need to deal with that? How we can get rid out of those kind of gaps and non-compliances so that we should be able to serve the community, serve our profession, serve to our management or client better. With this, I would start my presentation with apt topic, which has been, I would say, suggested by Deepa. Initially, I was trying to take only and only FDI part and compounding and contravention. But thereafter, when requests come from Deepa, look, we also need to cover. There's no harm in taking ODI as well. Therefore, the topic which is going to be covered today is foreign direct investment, particularly having a capital contribution or a partnership stake in India and in the form of a company, LLP, etc., or having a presence of a non-resident or a person resident outside.
I had requested Deepa ji to further request you that we should cover this topic in the most holistic way. So
Sure.
That is why she made a request to you.
Dhananjay, the rest assured. Apart from what we are taking, whatever the questions are there, whatever if time period, whatever comes from it, definitely I'm bound to take it.
Sure.
And rest of the thing I'm sure can be taken care by way of asking questions by the participant. And I'm sure and confident, even if some of the topic which our participant may not be able to or will not be able to, I'm 100% sure you are here to ask those kind of questions, and I'm bound to respond to that.
Thank you.
Yeah. One is we are going to cover FDI. We are going to cover license office, branch office, or project office in India. We are also going to cover outbound investment, Indian multinational, that is by way of setting a joint venture or wholly owned subsidiary or overseas portfolio investment, or having a presence outside India in the form of a license office, branch office, project office representative outside India. That means I'm going to cover majorly today both part inflow and outflow for the purpose of establishment of a place of business outside India or in India by whatever the name, by whatever the vehicle which has been provided, and also going to capture if those gaps has not been fulfilled, if those gaps under the compliances are there, which we in language, in our language, say contravention, how we can fill those gaps out, and what are the provisions available to us for the purpose of regularizing of those non-compliances. Of course, all of us know that foreign direct investment is one of the major area for our country to attract more and more foreign investment, to have more and more foreign exchange in India. As a matter of practice and convention, I would like to take you to the back when in the 1947, when the British government has started were going out of the country. At that point of time, immediately before that, they have constituted an act called Foreign Exchange and Regulation Act. Immediately after independence, this act has been, as it is, adopted by the Indian government as well. And Foreign Exchange Regulation Act has been, as it is, which has been promulgated by the previous government, previous Britishers, I would say, has been immediately taken into the effect, or has been advised to be continued in the same fashion and manner. When it comes to Foreign Exchange Regulation Act, at that point of time, it used to be there was a reserve of foreign exchange reserve of 63 million GBP, because at that point of time, the common currency for reference was GBP, because the Britishers were ruling us out. Later on, which has been converted into foreign, and now you can see the foreign exchange reserve position is crossed billions, and I'm sure one day will come when it goes to trillions as well. The position has been improved over a period of time. When the Foreign Exchange Regulation Act was there, more and more dependence was there on the import, less export was there. We were finding hardly any foreign investment by way of foreign direct investment into the capital contribution, because India was in a different situation. That act further got amended in 1973, Foreign Exchange Regulation Act. Name had continued with an objective to conserve the foreign exchange, more particularly, and I would say the provisions used to be Draconian provision from the perspective of almost everything was prohibited, barring few things which has been permitted, and that too, where whatever the things which were those were permitted, that too with the prior permission of Reserve Bank of India. You need to go to the Reserve Bank of India offices, not to the bankers, which is prevalent nowadays, which is a practice followed nowadays. Each and every time you have to go to the central bank which is situated at Mumbai, or unless few of the area or the power which has been delegated to the regional offices of Reserve Bank of India. Huge line used to be there. Even if for purchasing the foreign exchange, people tells me, look, there used to be days when the kilometers of the line used to be there whenever someone is, traveling abroad in order to earn the foreign exchange, in order to procure the foreign exchange for the purpose of payment of ticket, hotels, and other charges. There used to be huge line in front of the Amar Building, Reserve Bank of India. For 3 days, 2 days, 5 days, the person used to stay there, and thereafter you are procuring the foreign exchange. And believe me, there used to be 38 pages form, 34 or 30 pages form with all these carbon copies, where the all declaration, etc. was supposed to be given. And you need to give the iteration that from where you are going, what for you are going, and which country. If it is a hopping trip from one country to another, you have to give. And in case any change in the plan or travel plan during that particular transit take place, that also need to be reported once you come back to India. Those kind of foreign exchange provision was been there. And any gap in compliances, any contravention, any non-compliance of the foreign exchange regulation was considered as a criminal offense. Person was supposed to be put behind the bars for a 60 days trial. And after that, the fate would be decided by Reserve Bank of India, whether those kind of things need to be imprisoned or penalty can be imposed. Even the penalty was there during those times 5 times, 7 times, and 4 to 5 year period of 4 to 5 period of imprisonment was used to be there. Then things over a period of time changes. Industry has demanded, look, the way the government is dealing with this kind of issues and imposing those kind of penalty is not in the interest of the business. Therefore, a committee has been constituted in the name of the Jain Committee. Ashok Kumar Jain ji has been created, and new act has been promulgated or amended. Act, I would say, come into force with a new name. New thing has been provided by way of Foreign Exchange Management Act 1999, made effective from 1st June 2000. Almost everything has been permitted, barring few things, those have been prohibited. Act has been divided into 2 parts, current account transaction and capital account transaction. Current account transaction are particularly if you talk about a transaction, those relate to the profit and loss account, which is trade-related transaction or income from loan or investment, etc. And when it comes to capital account transaction, for sake of convenience for your understanding, you can say anything which is tampering or altering the positions of the assets and liabilities of the company or the balance sheet or financial statement. Those have been covered under the capital account transaction, such as inbound investment, outbound investment, foreign borrowing, Indian currency borrowing, foreign currency borrowing, and so on, and acquisition of immovable property in India, acquisition of immovable property outside India. Those are the items. I'm sure all of you also know the account well. Those find place in the financial statement of the company in the assets and liability side, that is in the balance sheet. And most of the power over a period of time has been delegated, has been given to the authorized dealer for the ease of convenience. Even for the purchase of the procurement of the foreign exchange, it is the concept of authorized person, which includes commercial banks, scheduled banks, and full-fledged money changer licenses has been issued to various organizations, various persons who are eligible to meet the minimum net on fund or net worth requirement, say 25 lakh rupees or so and so forth. And not only the act has been newly constituted, and it has also been stated, what if, in case any contravention continuity is there from the previous laws, and action need to be taken by any authority, be it as Reserve Bank of India or be an investigating authority. Concept of sunset clause has been put into place. 2 years consent clause has been provided. And it is categorically provided and prescribed over there. Look guys, once this act has been implemented, made effective from 1st of June 2000 up till 30th May 2022, whatever the action from the previous law need to be taken, that should be concluded, or that should be initiated, should not say concluded, that should be initiated by 30th May 2022. Therefore, no litigation, no non-compliances of the previous will be carried out for a lifetime. There has to be some time and process. And not only in the Foreign Exchange Management Act, the concept of current account transaction, current and capital account transaction has been introduced. The concept of civil law has also been introduced. Act has been converted from criminal law to civil law, and that too compoundable by way of imposition or payment of penalty by the contravenor or the wrongdoers. And now, over a period of time, new concept of late submission fees has also been introduced, just like your ROC payment. In case any reporting and form which was supposed to be, form-based reporting or return, if any return was supposed to be submitted has not been submitted within the time, they have already provided, look, this is that percentage of the amount involved. For a next 3 year period of time, LSF facility, late submission fees facility is available, and thereafter you can go for a compounding. That means if 3 year period has been expired. The nuances and the nitty-gritty of the LSF and compounding also we are going to discuss. Coming back to the foreign direct investment, if I see the legislative framework, it has been started from the Foreign Exchange Management Act 1999, Foreign Exchange Management Non-Debt Instrument Rules 2019, Foreign Exchange Management Mode of Payment and Reporting of Non-Debt Instrument Regulation 2019, Consolidated FDA Policy issued by DPIIT, Department for Promotion of Internal and International Trade, under the Ministry of Commerce and Industry, Press Note issued by DPIIT and the Ministry of Commerce and Industries, and notification circulars issued by Reserve Bank of India or Ministry of Commerce and Industry from time to time, right? And almost on a year-to-year basis, a consolidated master directions are being issued by Reserve Bank of India in order to capture the amendment and the consolidation at one place. But of course, it would continue to be dealt with a notification which has been issued by Reserve Bank of India from time to time. Various notifications, circulars, permission has been run, notification and circulars has been issued by Reserve Bank of India. All need to be read together from the perspective of understanding and implementation. When it comes to FDI overview, friends, it has been divided into 3 parts. Prohibited part, which is also known as a restricted part, and it has also been divided restricted approval route and automatic route. When we talk about the restricted list, restricted part, that means prohibited part, these are the sector which has been there where foreign direct investment is not allowed. That does not mean Indian investment or domestic investment can't come. The restriction is, since we are reading and we're talking about the foreign investment, Above extreme right one, which we are talking about, is restricted list or prohibited list, where the sector, because if I see the overall concept of the scheme of the Ministry of Commerce and Industry, they have divided this into the sector wise, in the which sector this investment can come. That means the sector means business activity, like in betting, gambling, and lottery, chit fund and nidhi company, real estate, except construction development and REIT, tobacco product, trading and transfer over development right, atomic energy and railway operations other than permitted activity. Under these 6 areas, investment as a foreign direct investment is not allowed at all. When we talk about the betting, gambling, lottery, speculation, these kind of things, there is a thin line of difference between game of chance and game of skill. When it comes to game of skill, definitely it is permitted, but when it comes to game of chance, it becomes a speculative in nature, and therefore it would be treated as a gambling or betting and speculative in nature. Though there is a thin line of difference depending upon the effect of the case, you need to analyze and advise. And in case you are unable to find so, you can always approach to Ministry of Commerce and Industry by way of for seeking a specific clarification, giving the detail about your business activity per se. Look, this is what my business activity. This is how it's been carried out. These are the precedents available. These are the peers how the peers are being doing this kind of thing, and you advise me. To my mind, this falls under the automatic route, but still would be guided by the DPIT wisdom. Therefore, as and when this kind of things comes to your mind, don't ever take any kind of chance. Please approach to Ministry of Commerce and Industry for specific clarification and confirmation. Not only that, more particularly for betting, gambling, lottery, speculation, game of chance, game of skill, game of chance, etc. In this sector, not only FDI is being prohibited, also any kind of commercial arrangement or a commercial arrangement amongst them within Indian party and overseas by way of like training arrangement, any foreign collaboration, any joint venture agreement, any kind of support services, that is also been prohibited. For this sector, there is complete no from the perspective of going and getting investment out of the country. Then it comes to approval route. There are 11 sectors, those are only and only requiring the approval nowadays. Rest of the act has been done away since long. Sector not falling under the automatic route, investment only post obtaining approval from the concerned administrative ministry and DPIIT. Only then, once this approval from the concerned ministry has been taken, then only it has been allowed. The sector those are falling under the approval routes are defense, small arms, broadcasting, print media, civil, aviation, satellite, telecom, private security agency, multi-brand retail trading, minimum investment limit of 100 million, not more than 51%, and 50 million also need to be spent on the creating of infrastructure. Unregulated financial service sector, banking and pharmaceutical sector. Pharmaceutical sectors only when it is a brownfield and beyond 74%. When it comes to financial service sector, it is interesting for us, friends. Nowadays, I have seen people are more and more particularly post-pandemic, business is more and more increasing in the fintech sector, financial service sector, be it is a payment gateway, be it is a PPI, prepaid instrument, be it is a NBFC, be it is a CIC, core investment company. Some of the sectors are regulated. Some of the sectors are unregulated. Some of the sectors we have a doubt. If those are exempted, not required registration, or under doubt, you can always approach to Ministry, or you should always approach to Ministry of Commerce and Industry, and they will prescribe you to approach to the Ministry of Finance, the Department of Economic Affairs for seeking a specific clarification and confirmation. Not only that, if any person intend to invest in India in a holding company, and from their holding company, they're going to invest into the intermediary subsidiary company, then again, any investment, if it is a pure holding company, that require prior permission of Ministry of Commerce and Industry. And Ministry
sir,
yes.
Could we take up relevant questions in between the sessions? Also,
no, we will take the session
at the end.
No, we will take it in the end. Otherwise, the flow will be disturbed.
Okay.
Because there are a number of topics which need to be covered. Right? Therefore, whenever there is a doubt, when it comes to financial service sector, more particularly if it is an NBFC, automatic route. If it is an CIC, prior approval of Government of India. If it is a non-fund based or fund based, if it is a financial service sector which is not regulated, which is exempted or not required to be registered, or if we have any doubt about the business activity, whether they should follow it or not. Under all these four situations, you need to approach the ministry for seeking approval. Again, as I stated, again, from the perspective of holding company, if it is pure holding company, of course, not only requiring the permission from the Reserve Bank of India as a CIC, but also approval for the purpose of downstream investment. But in case it is an operating come investment company, no prior permission is being required. However, the benefit is been there. Fortunately, there is no percentage which is being prescribed. Even if operating company, out of operation, there is a revenue of 5%, 10%, 20%. The rest of the income is coming out of the financial service sector. So far, there is no compartmentalization has been taken place. Therefore, till that time, we have a benefit to pursue with that. An investment by non-resident entity of a land border sharing country, as per Press Note 3 issued during the pandemic days, any investment which is coming from those countries having a land border. This is not Deloitte's view, which I'm talking about now. This is my personal view. The countries list has not been issued by ministry so far. Generally, the countries those have been considered are Pakistan, Nepal, Bhutan, China, Macau, Taiwan, and Hong Kong. These are the countries generally being considered from that particular list. People have a debate on Taiwan, whether they should be covered or not. Ministry also sometimes have a debate. Till the time clear guideline has been issued, these kind of things are generally being considered are the list or the member of a land holding country or country, those are having those are sharing land border. You may, for the purpose of benefit, you should always approach before inviting investment, if from such country, to your authorized dealer bank. They will able to guide you or write to the ministry specifically in their question answer portal. Like, these are the country I'm saying, what is your view? Whether should we go ahead for seeking necessary approval or not? Practically speaking, those kind of approvals are taking time, 8 to 12 month period of time, or some cases I've seen 2 years, 3 years, nothing to comment. And but of course, those prior permission from those countries required. Unfortunately, I'm deliberately using this word. Even if it is a 1% shares, and they're talking about directly or indirectly, when the ultimate beneficial owners is relating to those countries. I have a case. I have handled so many cases nowadays with this. Even if it is a company, say Singapore-based company, which is listed on the Singapore Stock Exchange, right? And because of the listing status, someone, somewhere, say 1% at 10 share or 100 share or 20 share, 20,000 shares has invested from Pakistan, having no mean to control, no reason to control affairs of the company, etc. And I would say practically there is no role or involvement for day-to-day operation or the policy decision. They're just acting invested in as say for portfolio. Even in those kind of things, you need to have a specific approval from the ministry, because the onus is on you to verify or to justify. They're talking about UBO. Even the percentage has not been prescribed. UBO for your BEP of Companies Act also can't be considered. Therefore, you have to be mindful. Not only that, if any merger is taking place, there is no foreign exchange inflow has been there. Any existing company is there, merger is taking place, same shareholder X is merging with Y, and B shareholder is going to A, becoming the shareholder as equivalent to the A, even in those cases. Not only that, ESOP is being issued. Number of cases nowadays we are handling when employees have been granted ESOP when they were resident of India. They moved to their wholly owned subsidiary or joint venture outside India. Company got listed, and thereafter they are exercising during the course of listing or thereafter. And incidentally, the country from where they have shifted is China or Hong Kong, or China or Hong Kong, example. Even if that kind of a prior approval is required. Not only for that fund flow scenario, right issue, bonus issue, ESOP, M&A, buyback, those kind of things. Even in those kind of scenarios, of course not buyback, even in those kind of scenario, you have to have the prior approval from the government. Government has never ever bothered to give any kind of clarification and confirmation. This is highly debatable issue, but still, situation is as of now this. Forward, I would say in a way, it's good for professional. Each and every time you have to approach in the ministry for seeking approval. When it comes to automatic route, almost all the sector are under automatic route. No prior approval requirement. Only the post facto intimation that a filing is required to be given, that to the FCGPR. Either from foreign remittance or NRE or FCNRB account maintained in India, not from NRO account, right? Subject to applicable laws and regulations, security and other conditions. Sectors are IT, ITS, service sector, infrastructure, manufacturing, so on and so forth. The beauty of all these three lists are, friend, if any of the sector is not falling into the list which has been prescribed over here in automatic approval and restricted, investment in that sector is under automatic route. This is the thumb rule you have to keep in mind. Now, we have decided, yes, what all sectors are available for foreign investment. Question comes, who could be an eligible investor and what kind of instrument can be issued? Eligible investor could be any non-resident entity, individual other than land border sharing country. FPI in terms of Schedule 2, citizen or entity of country sharing land border with prior approval of Government of India, SEBI registered FVCI, NRI resident and citizen of Nepal and Bhutan in terms of Schedule 3 and 4. Erstwhile OCBs, Overseas Corporate Body, can also invest subject to approval from the Reserve Bank of India or concerned ministry as the case may be. Company, trust or partnership firm incorporated outside India and owned and controlled by NRI in terms of Schedule 3 and Schedule 4. Friend, this is interesting to note. If an NRI intend to invest in India, there are two routes available to them. And this route is available only and only to NRI. And NRI has the flexibility to invest either on repatriable basis or non-repatriable basis. If they are investing on non-repatriable basis, they have option to send the money from outside India and invest into the country, invest into the company. If they intend to invest on non-repatriable basis, they can invest through NRI account maintained in India or from outside India also. But no form, no reporting to Reserve Bank of India is required to be made, because if it is not a if it is not on repatriable basis, it is on non-repatriable basis, it would be treated as a domestic investment. If it is treated as a domestic investment, therefore, FDI policy will not apply to that. You have to keep it this mind. Not only this facility has been extended to NRI, but entity owned and controlled by NRI also, that has been extended. When it comes to long-term investment like insurance funds, pension funds, foreign investment funds, etc., etc., etc. Once you have gone through, once you get to know, this could be our eligible investor. Then question comes, what could be eligible instruments? Instrument could be equity shares. When it comes to equity, there has question come, equity could be fully paid up or partly paid up. If it is partly paid up, the condition is minimum 25% need to be received upfront. Balance has to come within a period of 12 months. No, in equity, you have an instrument of warrants. If it is a warrant, definitely within 18 months you have to convert those warrant into the shares capital. Apart from equity, you can invest only and only equity linked instruments. That means those are instruments, those are convertible in nature and convertible only and only into equity. Fully compulsory and mandatory convertible debenture into equity, fully compulsory and mandatory preference share into equity, convertible notes by startup, capital contribution in LLP, DRs and FCCBs, and sponsored ADR and GDRs. When it comes to, once you get to know where the investment can come, who could be an investor and what instrument can be issued. If the equity need to be issued, if it is a fresh issue, definitely it is a preferential allotment. Fresh issue, listed company as per SEBI guideline. If it is an unlisted company, valuation carried by chartered accountant to category 1 merchant banker based on any acceptable international acceptable principle on arm's length basis. However, this initial condition would not apply on a subscriber to the memorandum of association. When it comes to preferential allotment and right issue, when preferential allotment for listed company as per SEBI guideline, unlisted company not less than the fair value of the shares arrived by chartered accountant or SEBI registered merchant banker or cost accountant based on internationally acceptable practice on arm's length basis. When it comes to right issue, there are only two conditions. Listed company as per price determined by the company. By unlisted company shall not be less than the price offered to a resident. When it comes to transfer of shares, same principle will apply, but in a different manner. When it comes to resident or non-resident, listed company, not less than the price at which a preferential allotment can be made at SEBI regulation, as per the SEBI regulations. When it comes to unlisted company, same principle, sir. Not less than fair value of the share arrived by chartered accountant or SEBI registered merchant banker or cost accountant based on internationally acceptable practice or a company internationally acceptable practice. Friends, you have to keep in mind when it comes to resident to non-resident, resident should receive, in this case, transfer by resident to non-resident. Resident should receive minimum fair value. When it comes to non-resident, when non-resident to resident should not pay more than the fair market value. If it is a listed company, non-resident exceed the price at which the preferential allot price will be made. You have to keep it fundamentally clear. No more money can go out of the country. You can receive more money by way of and cashing or getting premium. When it comes to convertible instrument, put option and call option is there. There is a concept. I remember those days in 2012 and 13, when Reserve Bank of India has come up very heavily on the most of the real estate company. They used to have a put option clause. They used to say after 18 months, 12 months, 60, 33 years, 2 years, or sometime 9 months, etc., put option and call option will be exercised. They were Indian buyer, or particularly the promoter, will purchase the shares at a 30%, 35%, 38%, 40%, 60% of the IRR. That means you're assuring the price upfront. Forget about the forward contract and derivative, etc. in terms of the listed company, because most of the time we have seen the cases when the private limited company generally doesn't fall into those kind of scenario. Reserve Bank of India came up very, very heavily. They said, in case you're assuring someone is a return, a specific return, it is no more in the form of an equity shares. It is in the nature of a debt and a loan. Therefore, they came out with the principle, A, no assured return should be given. Minimum lock-in period of 1 year or such higher period as may be prescribed under any other law. And whenever they're selling it off, it should be based on the internationally acceptable practice, price determined by the chartered accountant or cost accountant or merchant banker in terms of the or register value in terms of the internationally acceptable practice by on arm length basis. On arm length basis. This is about the private pricing. We get to know where has to invest, where we need to invest, which sector we need to invest, who can invest, what kind of instrument we can get, what kind of price we have to pay. Now comes to certain other corporate actions. During the currency of the organization or the company, you came out with further issue of shares by way of right issue or a bonus issue. When it comes to right issue and bonus issue, share warrants are not allowed as a right warrant or a bonus warrant. Adherence of the sectoral cap, share acquired as per NDI rules, compliance of the Companies Act. Pricing again, friends, same, not less than for unlisted company, not less than the price offered to the resident. For a listed company, price determined by the company. Fund should come through NRE from the outside, NRE or FCNRB account. One thing you have to keep in mind, assuming a person resident outside India who has acquired right from a person resident in India who has renounced that. I'm sure you must be aware in terms of section 42 and section 62. Right issue can be given. Right issue can be given without assigning any price. That way face value can be given because right is a preemptive right. All the existing shareholders are subscribing to the share. There is no pricing guideline as is applicable on right issue. But when it comes to listed, from foreign exchange perspective also, there is no restriction. You have to charge minimum. But inbuilt right with the right issue is right of renouncement. Assuming you are renouncing your shares in favor of non-resident. If you are renouncing the shares in favor of non-resident, be the same shareholders or to another shareholders, definitely they are getting additional shares. In a way, it would be seen as a color of a preferential allotment. Therefore, 3 years ago, Ministry of Commerce and Industry came out with the principle: if to the extent the portion which belongs to the preference virtually renounced in favor of a non-resident to pay at the preferential allotment price, that is a international fair market value. Otherwise, on right issue, there is no. Though they can opt to not to subscribe. But in case you're renouncing that right in the favor of a non-resident, it will be treated as a preferential order, hence the pricing guideline will apply. Certain corporate actions are there: merger, demerger, amalgamation, and arrangement. 2 or more Indian companies are merging or getting amalgamated. And the shareholder of B company, Y company, being X, B shareholder B, is becoming the shareholder in A company on account of merger of B with A. Merger of Y with X, sorry. When Y is get merged with X, then definitely that is allowed, subject to sectoral cap, pricing guideline, and everything. Therefore, we have to keep in mind those are the following condition. May issue equity instrument to the existing shareholder subject to compliance of entry route, sectoral cap. In case of breach of sectoral cap, assuming someone is getting more than the prescribed limit, then the government approval is required to be obtained. Transfer or transferee company not to engage in the activity prohibited by the LODI. Listed company shall also need to follow the LODR guideline, and the scheme should be approved by the honorable bench of the NCLT or the competent authority. Additional benefit which has been provided. Sometimes what used to happen during arena, when NCLT was not there, only High Court was there. What we used to do, we used to draft the scheme of corporate restructuring or scheme of compromise and arrangement, where equity shareholders are getting redeemable instrument or getting some cash on account of their holding in India, in the company. By and large, we were getting this approved by the Honorable High Court, and that order was submitted to the Reserve Bank of India for seeking clearance for the purpose of making remittance, or to the particularly generally to the authorized dealer for making remittance. And once it has been done, by and large, Reserve Bank of India or the authorized dealer generally don't stop that, because otherwise it would be treated as a contempt of court. But after constitution of the NCLT has started ordering subject to FEMA compliances. When it comes to Reserve Bank of India or the Reserve or authorized dealer bank, generally those proposal, if it has been approved by the NCLT, even if by NCLT has approved it, since the FEMA doesn't talk about, because NCLT, the difficulty or the, I would say, most ironical system is whenever the NCLT is or issuing the order, they're saying this order has been issued only and only from the perspective provisions of Companies Act 232 to 35. Right, sir? Right, friends? And this order should not be treated as an order or considered as an order under any other act. Though, by and large, in past, some of time, court also used to say that, but majority of the time, this was happening. Therefore, when it goes to Reserve Bank of India or NCA or to authorized dealer generally, by and large, stops that. They said, since the basic principle of the FEMA is no instrument, equity can be converted into the payable. That means redeemable, because if it is a redeemable instrument, non-convertible instrument, optionally convertible instrument, it will be treated as an ECB. If it will be treated as an ECB, by devising this mechanism or going to the NCLT, you cannot use this kind of colorable device. Therefore, this is not permitted. Only exception which has been created by way of circular by Reserve Bank of India is if the company's financial statement is having general reserve, and out of the general reserve, you are issuing redeemable bonus, debenture or preference share to the existing shareholders of the company, then it is permissible. A presence of general reserve has to be there. Only then those redeemable instrument in the form of a instrument in the form of those instrument has to be there. Only when the exception circumstances. What was the reason and genesis for bringing this kind of clause? I can discuss with you offline, not on this public session. But there was a reason for accommodating someone to bring this kind of provision. Therefore, this kind of $93 billion transaction has been done because of this account. I can share this separately offline to accommodate. But in any case, the public at large also get benefit in case you're having a general reserve. Out of the general reserve, you can issue the bonus redeemable instrument to your shareholders. When it comes to merger demerger, we are going to cover separately inbound and outbound merger, but moving down to sweat equity and ESOP. ESOP, sweat equity, any kind of long-term instrument in favor, it is also allowed without any percentage sectoral cap. As long as sectoral cap without any percentage limit, which used to be there earlier, 5% to the employees, director or company or holding company, joint venture, wholly owned subsidiary are eligible. And if it is under the approval route, prior approval of government, if it is not under automatic route, if it is not under government route, then no prior approval is required. But the only point you have to keep in mind, if any person, which I covered in the beginning, any person who was resident at the time of grant of shares, hold the shares on non-repatriation basis, right, become non-resident, that does not mean they can get it converted into repatriable without prior approval of Reserve Bank of India. Reserve Bank of India is not going to consider such kind of approval. We have seen it practically. Therefore, if someone has been granted as a resident, become non-resident subsequently, at the time when those right has been given, despite the money has not been provided by him after completion of grant can be vested only after expiry of vesting period of 1 year minimum, right? If you know I'm sure you must be aware of the ESOP policies provision, and that in the terms of the exercise period prescribed over there, right? If it is the case, not acceptable, it should always remain as a non-debatable. They can subscribe from the NRO account or they can send money, but the money share should be allotted as a resident domestic investment. Any proceeds of sale has to be transferred to the NRO account. From NRO account, you can take it out of the country by way of $1 million. When it comes to conversion of legitimate dues into the equity, instead of paying cash, you can convert your legitimate dues into the share convertible instrument. Legitimate dues could be lump sum, technical know-how fee, royalty, ECB, import of capital goods, machinery, equipment, excluding second-hand machinery, and other funds payable by the investing company, remittance, which does not require government approval or approval of Reserve Bank of India. It may be possible, like some time period is there for the purpose of import, 6 months or 36 months. That period is expired. Now you want to convert that into equity. You have to take the prior permission of Reserve Bank of India. Or if it is a sector which was requiring a government approval, you require to have a government approval first, then only it can be converted. Condition, sectoral cap and pricing guidelines, general condition, GOE approval for conversion sector falls into the FDI route. Rate of conversion shall be available on the date of agreement, conversion rate available on the conversion. However, if it is lower than that, you can convert it, but if it is, however, RBI will have no objection if the borrower company wishes to issue shares or convertible for a rupee amount less than that arrived as per the mention above by the mutual agreement between the parties. And conversion should be net of taxes. Reporting requirement, again the same FCGPR. And if it is ECB2 return marked with partially conversion or fully conversion. When it comes to downstream investment in a scenario when you're having an intermediary holding company, overseas company invest into say overseas company, say FCO1 invest into the Indian company called ICO1, pure holding company or holding investment company. That company further invest into ICO2, ICO3, ICO4, ICO5, and so forth. If that Indian company 1 is having more than 50% or more from outside India, it will be treated as a foreign owned and control. And thereafter, the downstream investment will take place depending upon the sector in which this ICO2, ICO3, ICO4 operate. If ICO2, ICO3, ICO4 operate in the government approval route, they need to take the prior approval of Government of India. In case they do not carry their business activity, fall into the government route, automatic route, in that case, you can make an investment under the FDI guidelines. The compliance of the FDI policy rules and requirements to be taken place, and approval of the board of directors would be required. Major two conditions are there, friends. Fund, the money which is going to acquire the shares of the ICO2 in our example, should be either FDI proceeds or internal accruals. FDI proceeds or internal accrual. No leveraging from fund from the market can take place, and the responsibility of filing D1 and D7 is first level Indian company shall be responsible for compliance for second level, and so on, and downstream investment and obtaining an auditor certificate annually in this behalf on an annual basis. These are the complete things you have to keep in mind when it comes to them. Friends, apart from where we can invest, who can invest, what instrument can be issued, corporate action, conversion into equity, and last but not least, from the FDI perspective, cross-border merger. You must be knowing that New Companies Act, which has been enacted or announced effective from 1st April 2014, right, made life easy inbound and outbound. Earlier also inbound was allowed, outbound was not allowed. Now it says inbound merger is allowed. That means overseas company merge with the Indian company. Friends, just take an example, and you need to be concentrated over here. There is an Indian overseas company, say Jupiter Inc., based out USA. Jupiter Inc. is merging with your Telecom Inc. India. Jupiter is merging with the Indian company. Pure court driven or whatever the process of the country of the overseas is there. In India, definitely the NCLT is the only jurisdiction over that merger. Overseas company FCO is merging with ICO1, assuming. FCO1 is having non-resident shareholders. Of course, it is outside the country. Right, sir? It's a foreign company. They may have certain other subsidiaries, certain other joint ventures. They would have taken loans. They would have other offices, other places. They would have taken funds from the market. deposit, etc. They would have set up any joint venture or wholly owned subsidiary in other country, may or may not be in India as well. They may be having certain bank account. They would have taken guarantee. They would have given guarantee. They would have acquired immovable property, etc., etc., etc. By way of merger, I'm sure all of you are company secretaries. No merger amalgamation provision. Well, 230, 235, all asset and liability pertaining to the company of the transferee company shall become the property of transferee company. Right, sir? And shareholder will get the consideration. In consideration of the merger, shareholder of the transfer company will get the shares in the transferee company. If overseas company FCO1 is merging with the ICO1, then all these things will subsume, all will be assumed in ICO1, their shareholders. Therefore, if the shareholders are becoming the shareholder of Indian company, they should be FDI compliant. Right, sir? That means sectoral cap, pricing guidelines, land sharing, etc., etc., etc. If those overseas company having subsidiaries outside India, now those subsidiaries, earlier it was subsidiaries of FCO, you have no role, but now it will become your subsidiary. Then you have to comply with the ODI guideline, or 4 times net worth, subsector, real estate, and those kind of stuff you have to keep in mind. If any branch office raises RO, branch office or representative office, those will become resident. Indian companies, BO or RO, you have to keep in mind the guideline which has been described. Any guarantee asset abroad or bank outside India, those will also become your asset abroad. The flexibility has been provided. You can continue to hold those assets by a guarantee asset abroad or bank account in India for the next 2-year period of time. If you are complying with this condition, automatic route is there. And mind it, Reserve Bank of India has covered only merger, not the demerger. There is a leading judgment. I don't want to quote that name. 4 years ago, NCLT Mumbai has rejected that case because invariably regional director of the Ministry of Corporate Affairs sought an clarification from the Reserve Bank of India. There was a scheme for FCO1, part of the business, they were demerging and merging with the Indian company. Matter went to the NCLT. They were under the impression it is under automatic. Some great consultant advised them it is under automatic note. No need to go to Reserve Bank of India. RD picked that point, sent it to Reserve Bank of India. Reserve Bank of India said it is not under the automatic route. NCLT rejected the proposal. Therefore, as a matter of practice, friends, I am suggesting you, sometimes you may face this heat from your promoters or the client. No, it is clearly written as an automatic route. Therefore, why we are going? Still, I would suggest seeking a specific confirmation or concurrence from Reserve Bank of India. Particularly, demerger cases under kind. If it is a merger, I am sure it is under automatic route, but there is no harm in taking into confidence your authorized dealer bank because the first level of query will be raised by your authorized dealer bank. You be mindful. It should not happen. Entire NCLT process has been completed, which is also nowadays is not an easy task. Years are been taken by them. NCLT with our great profession, I would say great authority, those are sitting, greatest authority. 9 months, 12 months, 15 months, 2 years, 3 years are being bloody taken for simple merger approval matters nowadays. 12 to 12 years. You have completed that period and later on, you get to know your scheme has been rejected on account of this. Better to take a permission from Reserve Bank of India or concurrence from Reserve Bank of India. It is a matter of, for this kind of matter, generally RBI don't take more than 2 month period of time in my practical experience, friends. Not more than that. You can run out that practice parallelly. I'm sure you all are aware when the application for NCLT first motion has been filed. 2 to 3 weeks generally have been taken for first hearing and thereafter second hearing. Second hearing has been there for 2 months, 3 months, depending upon the availability of the NCLT bench. Why you can always put a clause in your scheme. The parallel application with the Reserve Bank of India has already been filed. My objective is to share this point is to you should plan it in a structure it in such a manner while the proceedings in the NCLT is going on. We know these are going to take time. At least after first motion, by that time, more likely 99.9%, I would say 100%, you will get the response from the Reserve Bank of India. Then at that point of time, you have a reason or you can very well plan whether you want to continue with the merger or you want to put it on hold or you want to structure it differently. You can always modify this application and present before the NCLT. When it comes to outbound merger, same thing, sir. Overseas company is going with the merger. Overseas company. Indian company is merging with the overseas company. Now, ICO1 is merging with the FCO. ICO is having certain investment in India, certain shareholders, branches. guarantees, asset and road. Now we are flipping the structures. Friends, same thing. If the Indian company's shareholders becoming the shareholder of the overseas company, ODI rules need to be keep in mind, friends. Isn't it, sir? Or individuals are there. You have to keep in mind of the LRS limit of 250,000, sir, because individuals are becoming shareholders. Right, sir? When it goes LOBOPO, definitely. Overseas companies say ICO 1 is merging with the FCO 1. FCO 1, whatever the offices Indian companies having, they will become the LOB. Therefore, we consider LOBOPO for overseas company. Therefore, they need to comply with the LOBOPO. When it comes to guarantee, asset or bank account, same principle will apply. Overseas company can continue for a period of 2 years. If they want to, they intend to keep it for more than 2 years, or they believe that this kind of condition may not be able to be complied by them, then again, sir, seek a specific permission from Reserve Bank of India. This is what I wanted to share with you, the inbound and outbound merger. Then the simple principle we need to follow in case you're complying with this regulatory action. And another question you have condition which is there to avail automatic route or exemption is to no regulatory action should be there, no compliance, no contravention is to be there. Any transaction cross-border is exempted, and certificate from the MD, W2 and CS if available, ensuring compliance to be submitted to the NCLT. If you are following these guidelines, you believe you falls into that, you're complying with that, no permission of Reserve Bank of India is required to be sought. Otherwise, you have to take the prior permission of Reserve Bank of India. When it comes to filing certain forms, FCGPR, all of us are aware, FLA, FCTRS, ESOP for ESOP, LLP1 for entry, investment, exit LLP2, downstream investment, SIA. There are two reportings to go to SIA. One is to secretarial for to the DI, to the Reserve Bank of India. Another is SIA reporting within 30 days of transfer to the Ministry of Commerce and Industry. These are the forms need to be filed, right? And when it comes to transfer of share, transfer from resident to resident, no approval, resident to non-resident, including NRI on repatriable basis, FCTR is required to be filed. Non-resident to resident, FCTR is required to be filed. Non-resident eligible on non-repatriable basis to non-resident, required to be filed. Non-resident to non-resident, required to be filed. If it is on repatriable basis and non-repatriable, and the buyer is on transferee is acquiring those shares on non-repatriable and non-resident Indian company purchasing shares pursuant to buyback capital reduction. Again, friends, because when the Indian company is going for a buyback or capital reduction, it is considered akin to Indian company being a transferee, being a transferor. They are selling the shares and therefore form FCTRS need to be filed by the Indian company to purchase the shares and pay the consideration. And non-resident, including NRI, on repatriable basis to another non-resident, not required to, because this is an NR to NR transaction. And NRI eligible investor on non-repatriable basis to non-resident, non-resident, including non-resident, not required, and resident to non-resident on non-repatriable basis, no. FCTRS is required to be obtained. This is all about our FDI policy, friends. And now we come to setting up a place of business apart from company or LLP in India by way of license office, branch office, or project office. When it comes to license office is nothing, only a communication channel, no trading, commercial, industrial activity. Project office is been established only and only for the purpose of establishment of a place of business in India for executing that project, which is generally called as what, friends? As turnkey project. And when it comes to other way of carrying out the business in India, branch office can be set up in relation to a company, means any establishment described as a branch office by the company to set up in India. These are the another mode of setting up business in India. When it comes to permissible activity, license office, parent company, promote export import from or to India, promote technical financial collaboration between parent or group companies and companies in India, act as a only and only communication channel, friends, no trading, commercial, industrial activity. When it comes to project office shall not undertake or carry on any other activity other than the activity relating and incidental to execution of project. That means Indian parties providing a contract only for a specific purpose. They should come and execute the project. Branch office, as per Schedule 2, they can carry out this business activity, export, import, rendering professional consultancy services, carrying out research work in which the parent company is engaged, promoted technical or financial collaboration between Indian companies and parent overseas company, representing the parent company in India, and acting as a buying selling agent, rendering services in information technology and development of software in India, rendering technical support to the product supplied by parent or group company, and representing a foreign airline or shipping company. Friends, if you see it carefully, these are all service industry, no manufacturing activity. Therefore, in case someone is intending to invest in India by way of setting a branch to carry out any manufacturing activity, answer is no. They have only two vehicles, either the company or LLP. When it comes to the eligibility criteria for setting up BOLO, branch office project profit making activity of 5-year financial year, and for license of it is 3-year, net worth of not less than 100,000 for 100,000, and for license of it is 50,000. If not financially sound, a letter of comfort from the parent company, group company, subject to condition that the parent company satisfy those criteria. And net worth here include total paid up share capital and free reserve minus intangible. This clearly mentioned. There is a clear mention over there. Next, minus intangible asset as per the latest financial statement of the company certified by the certified public accountant or a certificate. These are the points you have to keep in mind when you talk about the eligibility requirement. And when it comes to approval route, citizenship on sector and status of the applicant, we have discussed already. When it comes to the compliances, annual activity certificate need to be filed. LOBO shall submit an annual activity certificate at the end of 31st March every year to the AD Bank and Director General of Income Tax, and project office shall submit only AAC every year to AD Bank only. Single office of LOBO, PO, and there could be nodal offices also. One need to be declared, or you can have a multiple offices. Out of those multiple offices, you have to declare one, and that one office which you have declared, that office is responsible for filing annual return. AD Bank need to be submitted, and Director General of Income Tax. In case of multiple offices, a combined AAC can be submitted in form. AAC need to be submitted annually, friends, and this is a form which gives along with the financial statement need to be done and to be filed or before September 30th of every year. In case of annual equity account of the BOLO are finalized for a date other than March 31st, the AAC along with the audited financial statement may be submitted within 6 months from the close of the due date with a DGI. When validity of the LO is 3 years, subject to renewal, except for NBFC and non-BCF company and the company those are engaged in this construction and development. Then the validity is 2 years only and not required to be renewed, not eligible for renewal. Application for foreign bank and insurance, because I'm sure you must be knowing foreign bank is separately dealt by DBR, Department of Banking Regulation of Reserve Bank of India. From FEMA perspective, no separate permission is required to be obtained in case the DBR of Reserve Bank of India is already granting the approval. Likewise, for insurance company, IRDA is the authority. If IRDA is granting an approval, no separate permission from the Reserve Bank of India for place of business, that is branch, is required to be obtained. When it comes to special economic zone, same principle will apply to special economic zone also, because they have also given the power. When it comes to remittance of the profit, friends, branch offices and project offices, they can make an intermediary remittance subject to certified balance. Subject to, friends, branch office in India are permitted to remit profit or surplus outside India, net applicable of the Indian taxes on production of the following documents: a certified copy of the financial statement of the relevant year, and chartered accountant certificate certifying the manner of arriving the remittable profit, providing that entire profit has been earned through permissible activity only, and the profit does not include profit on re-evaluation of the asset of the branch funds. Likewise, for the remittance by PO, AD Bank can permit the intermittent transfer by project offices pending winding up lower completion of the project, provided it is satisfied with the bona fide of the transaction, subject to following condition, friends. The PO submit a certificate by auditor or a chartered accountant stating that the sufficient provision have been made to meet the liability and Indian, including income tax, and undertaking by the PO that the remittance will not affect the completion of the project, and shortfall of fund liability shall be met by inward remittance from abroad. When it comes to transfer of office, authorized dealer bank has been allowed to transfer the asset before the closure, subject to necessary registration if the company is registered with the ROC, and further the transfer of asset LOBO shall only be allowed the following condition, friends. First, the concerned LOBO PO intend to close operation in the company. The assets should have been acquired by LOBO from inward remittance, and not intangible assets should be included. Certificate from the statutory auditor shall be obtained stating that the date of acquisition, original price, depreciation till date, present book value, or written down value or and sale consideration. Confirmation from the statutory shall also be obtained that assets were not revalued after initial acquisition. Sale consideration should not be more than the book value in each cases. This is one of the hindrance point, friends. Very, very apt, but the regulations are like that. Only the book value sale consideration is to be there in case you are intending to fetch any profit. That is not allowed. And the AD Bank may permit the AO BOP to donating the furniture, computer, and other office systems items, etc., to NGO or other NPOs after being satisfied about the bona fide of the transaction, and any intermittent transfer of asset would be subject to prior approval of RBI. Meaning, thereby, there are two scenarios, friends. One, at the time of closure of your operation in India, you are selling, following condition need to be satisfied. When it may be possible, during the intermittent, during the currency of the project or going to the currency of the organization, you intend to sell, then specific approval from the Reserve Bank or authorized dealer required to be obtained. Of course, the procedure for establishment is identification of place of business, AD Bank and authorized representative, filing of application form FNC and AD Bank, RBI for intimation, seeking their approval, post receipt of UN number intimation from AD or from or to the AD Bank, registration shall be done with the ROC, obtaining a certificate of registration from the ROC and obtain the PAN number, registration with the state police authority by specific entities. The foreign entity who may have established a LOBO with the permission from central government during the pre-FEMA provision, they also need to apply to authorized dealer for the purpose of creation of an UN number. Mind it, friends, ROC registration is mandatory because that would be required also at the time of closure, a certificate from ROC. Closure of FBOPO, sir, evaluating the closure date of LOBOPO, filing of the E-form FC2 with ROC for closure, obtaining the closure certificate from the ROC, filing an application and annexure with the authorized dealer bank for transfer of asset and closure of the LOBOPO, obtaining the approval from the AD Bank on transfer of asset and closure of the branch office and the LO and BO. Once it has been closed, banker confirmation from the perspective of closure need to be sought, and you have to put it in file in record so that in future, in case some question has been asked, you will be able to produce that, yes, certificate has been there and closure report has been there. From the ROC side, not only from the ROC side, banker also giving the certificate because the bankers are generally maintaining LO, BO, registration, etc. With this, we conclude our discussion from FDI. Friends, now we'll move to quickly take a glance on overseas direct investment, friends. Friends, overseas direct investment rules and regulation has been amended most recently on 22nd of August. Major change has been taken place. I would say the law which has been there now is FEMA Overseas Investment Regulation 2022, notification issued by RBI from time to time, APDR circular issued by Reserve Bank of India. Apart from the regulation, Foreign Exchange Management Investment Rules has also been issued. Foreign Investment Direction 22 has been issued, and Master Direction on that has also been issued by Reserve Bank of India. I would say this is one of the finest piece of art has been issued by Reserve Bank of India. And fortunately, I was also part of those discussion and meeting with the Reserve Bank of India when this has been used. Most of the practical thing which was there earlier for RBI, which was granting on a specifically on case-to-case basis, those has been now put into the circulars by way of exemption, and those things which was not been there now still requiring prior approval of Reserve Bank of India. And what is ODI and OPI? They've brought out the concept of OPI and ODI. ODI means acquisition of unlisted equity shares irrespective of the percentage of holding. If it is an unlisted company, acquisition of unlisted equity capital, subscription to the memorandum and article, investment in 10% or more paid up capital of a listed foreign entity. If it is 10% and more, then only it is an ODI. Earlier, if you say joint venture of wholly owned subsidiary is wholly owned subsidiary 100%. For a joint venture, there is no terminology of the percentage of shares has been prescribed. Now it has been prescribed. If it is beyond 10 or more, then only it is an ODI. Otherwise, it is an OPI. Investment with control. It could be possible they are holding less than 10%, but majority of the board members are there with you. That means you are in exercise and control. In that scenario also, investment with control, where investment is less than 10% in foreign entity, that would still be treated as an ODI. Right? And investment classified as ODI shall continue to be treated as an ODI even if the investment falls to a level less than 10% or such percent loses control in the foreign entity. What is OPI? Overseas portfolio investment means investment less than 10%, Limit for listed company should not exceed 50% of its net worth based on the last audited balance sheet. And for investment listed company in India, permissible to make OPI including by way of open value investment of unit of overseas investment fund duly regulated by IFSCA, GIFT City. OPI post delisting, same principle, sir. OPI post delisting of the foreign equity continue to be treated as a OPI until any further investment is made in the entity. Who all are eligible investor? Listed entity, unlisted entity, partnership firm, registered partnership firms, registered society, resident individuals under LRS route, limited liability partnership, and registered trust having a 5-year trust and society, manufacturing and trust and charter document permit them. There are certain restriction and prohibition. Prohibited sector, restriction on investment, jurisdiction sector, sir. Prohibition, investment cannot be made from India in a real estate activity. Gambling, dealing in the financial product linked instrument. Restriction on investment, a person in India can make investment under the financial commitment in a foreign entity that is invested or invested in India through not more than 2 layers of subsidiary. Friends, there used to be a concept of round tripping. Now under the round tripping, earlier it was prohibited. Now saying, as long as it is well within the section 187 of the Companies Act, not more than 2 layers has been there, no approval is required. If it is more than 2, prior approval is required. Such restriction on layer of subsidiaries is not applicable to bank, systematically important NBFC, insurance company, and government company. Jurisdiction sector, if we talk about overseas investment or transfer of such investment, including swap of security in a foreign entity, again, friends, formed or registered and incorporated in Pakistan or any other jurisdiction having a or in a strategic sector specific geography shall require prior approval of Government of India. When it comes to mode of investment, friends, subscription to MOA or purchase, memorandum of association, acquisition through bidding, acquisition of equity capital by way of right issue with right to renouncement or allotment of bonus issue, capitalization of legitimate due, swap of security, merger, demerger, amalgamation or scheme of arrangement. Limits, again, same principle are there, sir, up to 4 times of the net worth and not more than $1 billion. When it comes to eligible instrument, equity listed could be listed or unlisted, perpetual or irredeemable instrument, fully and compulsory convertible instrument. Quantum of investment, in order to qualify for an ODI, it should be more than or is equal to 10%, as we discussed in the previous slide. If it is OPI, less than. If less than 10% with control, then again treat it as a ODI. Best instrument can be issued, can be invested, redeemable and non-convertible, optionally convertible debenture can be issued, guarantee can be issued, up to 51% performance guarantee can be issued. And friends, when it comes to Indian entity to meet the following condition, in addition to their percentage limit, should be eligible to make ODI, has already made in ODI, acquired control of foreign entity, acquired control of foreign entity for debt instrument to meet following additional condition, loaner backed by the loan agreement, rate of interest on arm's length basis. Mode of payment, sir. Mode of payment could be by through remittance through banking channel, funds held in account maintained as per FEMA regulation, swap of securities, proceeds of ADR, GDR, stock swap on ECB, investment by way of cash is not permitted, friends. No remittance to branch office outside for making any overseas investment. No payment on behalf of any foreign entity other than by way of financial commitment. Generally, we have seen, friends, people are setting branch office outside India after complying with the RBI regulation. Then they believe branch office is our extended arm. They say the branch office is our extended arm. Branch office is nothing, only an Indian company. In a way they feel. And they say, whatever belongs to branch belongs to us because it is not a separate liability, independent entity. Therefore, whatever the money, if lying there, they are purchasing, making payment, investing. RBI's categorically said no. Though we also used to take this kind of view, this view always, but now it is abundantly clarified by Reserve Bank of India. Pricing, again, sir, the issue or transfer of equity shares of a foreign entity from a person lied on entity to a person lied in India versus shall be subject to same, sir. Price arrived on arm's length basis, sir. AD Bank shall ensure compliance of arm's length pricing and guided by the Board of Approval policy. When it comes to deferred payment, sir, deferred payment for equity capital is permitted subject to following condition: upfront transfer of equity share capital from the buyer to the seller. Period of deferment shall be defined. Unlike in FDI policy, it is provided 12-month period of time for private partly paid up shares and for deferred consideration not more than 18 months. Full consideration shall be paid in compliance with the pricing guideline. Deferred part of the consolidation shall be treated as a non-fundraised commitment, friends, only. Then it is under automatic route. And indemnification shall be provided by the seller to the buyer and valuation in accordance with the pricing guidelines wherever applicable. And the pricing guidelines so far as noted, but has been continued to be like this only. In terms of erstwhile regulation, partial or full acquisition if it is up to $5 million, then CACPA if it is more than that, category 1 merchant banker or SEC registered or investment banker registered outside India. When it comes to after investment, when it comes to liquid transfer of shares or liquidation, person in India may transfer equity capital by way of sale to a resident or non-resident, subject to following condition. Same pricing guideline on arm's length and approval from the competent authority. In case of ODI, disinvestment by person in India shall be subject to condition stated as below, friends. In case of full disinvestment, other than liquidation, a transfer shall not have any outstanding due, which used to be there in past also, and the investment must have been held for a period of 1 year. Same conditions. When it may be possible you are not liquidating the company. You are just restricting the financial statement of the company by way of taking impairment of the assets, impairment, etc. A person resident in India who has made ODI in foreign entity may permit restructuring of the balance sheet. Restructuring of the balance sheet, friends, subject to condition. The foreign entity has been incurring loss from previous 2 years and evidence by its audited financial statement. Compliance with reporting documentation requirement. Friends, keep this particular point now in mind. Whatever the automatic route is available only and only to the entities, those have complied with the reporting requirement. Otherwise, automatic route is not available. Therefore, this has also been made as a specific condition for restructuring of the balance sheet, friends, compliance with reporting documentation requirement. And diminution in total value of the outstanding dues towards such person resident in India on account of, and read this word carefully, on account of investment in equity or debt after such restructuring, not exceeding the proportionate amount of accumulated losses. Meaning thereby, in case you have a wholly owned subsidiary, 100% is allowed. If you are holding 80%, only 80% is allowed. For balance 20%, you wait for another period or seek a specific approval. If the amount of original investment is more than 10 million, or in the case of where the amount is such diminution is exceeding 20% of the total value of the outstanding dues toward the Indian entity or the investor, that again, mind it, friend, outstanding dues here means it could be possible you made an investment and you have also exported certain things. Goods or services you have rendered from India. Dues could be on account of export of goods and services or royalty, technical or other dividend, etc. They are talking about dues and dues only and only with in relation to equity or capital. That means ODI related, not trade transaction or any other transaction. Outside over the Indian entity or investment, diminution value shall be duly certified on arm's length basis by a registered valuer or corresponding valuer registered with the regulatory authority, certificate CPI of the host country. Certificate should not be dated more than 6 months before the date of the transaction, and agreed investment in both the equity and debt of foreign equity shall be taken into consideration for computing this transaction. However, in case the transaction involve only equity investment, only in equity of foreign entity may be taken into consideration for computing proportionate losses. When it comes to forensic compliance, filing of FC form ODI has been replaced from FC at the time of making financial commitment, acquisition of equity capital through exercise of such right, and on restructuring disinvestment within 30 days. Evidence of investment, submit the evidence of ODI to the AD bank on acquisition within 6 months. Realization of proceeds, all dues receivable from the foreign entity with respect to the investment in foreign entity, amount of consideration received on account of transfer or disinvestment, net realizable value of the asset on account of liquidation of asset within a period of 90 days from the date of due. APR need to be submitted, duly certified by the statutory auditor or chartered accountant where the statutory auditor is not applicable, including the area of resident individuals. This form captures the changes in the shareholding pattern, financial position of the foreign entity, repatriation from the foreign entity, and detail of the step-down subsidiary. If the host country or jurisdiction do not provide for mandatory auditing, APR may be submitted based on the unaudited financial statement certified by such statutory auditor of the Indian entity or by chartered accountant where the statutory audit is not applicable. Need to be submitted timeline-wise every year by 31st December and where the accounting year of the such foreign entity and on 31st December The APR shall be submitted by 30th December next year. An exemption has been granted for submission of the form APR for PR person in India holding less than 10% in equity capital without control, and foreign company other than by way of equity capital, and if the foreign entity is under liquidation. From OPI, from for portfolio reporting, listed entity, listing Indian company, mutual fund, or AIF, VCF, employees, etc. within 60 days from the date of the half year, and APR need to be submitted by 15th of July every year, friends. These are the compliances with respect to ODI, friends. Setting offices abroad outside India, friends. Apart from joint venture or wholly owned subsidiary, you can set up a rep office, license office, project office outside India. Now, the conditions are for remittance. The conditions are only from the perspective of remittance. Of course, along with that, Pakistan, Nepal, Bhutan, etc. those are not allowed. Initial setup expenses at the time of setting of the office. AD may allow remittance for initial setup not more than 50% of the average annual sales, income or turnover during the last 2 financial year, or up to 25% of the net worth, whichever is higher. That means, whenever you are making a request to the authorized dealer for the purpose of making remittance, the authorized dealer need to ensure these are the limit which is prescribed for initial setup. For recurring, the limit reduced to 10% of the average annual sales, income or turnover during 2 years. Overseas branch has been set up in representative office to condition for the business activity, normal business activity of the company. Overseas branch office shall not enter into any contract or agreement in contravention of the Act, rules, regulation made thereunder. And overseas offices should not create any financial liability, contingent or otherwise, for the head office in India, and also not invest surplus abroad without prior permission of Reserve Bank of India. Any fund rendered surplus should be brought to the country, should be repatriated to India. Overseas office promptly to notify once they open the bank account to the ID bank, a remittance within the above limit for initial and recurring expenses also allowed by the authorized dealer to purchase immovable property only and only for this business or for residential purpose of its staff. And overseas office or branch of software export company or may repatriate up to 100% of the offsite and in case the company is taking on on-site project, they should repatriate the profits such as on-site contract after completion of the said contract. And only one annual compliance need to be carried out, and audited yearly statement showing receipt under offsite and on-site contract undertaking by the overseas office, expenses or repatriation their own may be sent to the authorized dealer bank, friends. This is a requirement from the perspective. By this, we have covered FDI, investment in Indian company, investment in LLP, branch office, LO, BO, PO, and we have also seen the investment going outside India in a vehicle called company, LLP, etc., LLC, etc., and also the branch office or representative office or license office outside India, friends. Inbound investment and outbound investment. Now the question comes, so many things has been read through, so many things has been heard, something has been understood, something has not been understood. Something has gone out of the window or out of the head. Question comes, as I always say, Savdani hati, durghatna ghati. In our favorite Hindi quote of Dhananjay Bhai, Savdani hati or durghatna ghati. What need to be done? That means something was supposed to be carried out, something need to be adhered to, has not been adhered to. Maybe you guys have came late, or you guys have not been in a position to recall or concentrate on them. Then friends, in that scenario, if it is a reporting requirement, then concept of late submission fees has been brought into the picture. For contravention is required to be paid. Delay in reporting, friends, made in respect of ODI, FDI, and ECB in India would attract LSF. Mind it, friends, LSF is there time and again for late submission fees of returns. Not any policy issue. Reporting are conditionally acknowledged subject to payment of LSF. No claim for refund in any manner of the amount already deposited. And friends, mind it, it is an option. It is not mandated. Authorized dealer bank advise you to go for an LSF. Condition form has been accepted subject to payment of LSF. You can always say, I don't want to go for LSF. I'm going for a compounding. It is an additional option which is being granted, but generally should not be adhered to because percentage of penalty here in LSF is far less than compounding. 73 for certain part it is 7,500 written, and for certain part it is 7,500 plus percentage which has been prescribed. This is a formula which has been applicable, which you need to calculate and accordingly pay the duty. And thereafter, if you are not going for a LSF or LSF is not applicable, in that scenario, provision of compounding is there with us. Any FDI related compounding. First of all, let's understand what is compounding. Compounding is nothing only a settlement of coming under a arrangement, not making a litigative, voluntary acknowledgement of the mistake and settling by way of payment of penalties or fees without making it litigative. Rates have been prescribed, matrix has been prescribed. Under FEMA, not more than 3 times of the amount involved in the transaction can be imposed as a penalty by Reserve Bank of India. Mind it, friends. However, in case if it is not quantifiable, then it is the enforcement director who can impose the penalty, but subject to maximum 2 lakh rupees and 5,000 rupees per day. Right. When it comes to imposition of penalty or compounding proceeding by Reserve Bank of India, all matter relating to FDI has been delegated to the regional offices of Reserve Bank of India. And the regional officer of Reserve Bank of India are empowered to settle the issue from the FDI perspective for the following: delay in reporting of inward remittance, delay in filing of FCGPR, delay in filing of annual returns and on FLA, delay in issue of shares of refund of share application money beyond 60 or 180 days, mode of receipt of payment, etc., violation of the pricing guidelines for issue or transfer, issue of ineligible instrument, issue of shares without approval of RBI, FIPB or government wherever required, delay in submission of Form FCTRS, taking on record the transfer of shares by investee company, delay in reporting of the downstream investment to the Secretariat for the Industrial Assistance, delay in reporting of the receipt of the amount of consideration of the capital contribution and acquisition of the profit shares by LLP, delay in reporting disinvestment, transfer of capital instrument of the profit share between the resident and non-resident, and gift of capital instrument by a person resident in India to a person resident outside India without seeking prior permission from Reserve Bank of India. Any delay with respect to central office from the perspective of contravention relating to acquisition and transfer of immovable property in India, contravention relating to acquisition and transfer of immovable property outside India, contravention with respect to LOBOPO, contravention related to current account transaction and deposit regulation, need to go to central office branch in Delhi. It is not a regional, though the office is in region Delhi, but it is still is a central office branch. Therefore, by having a place, if something has been settled by Delhi office of Reserve Bank of India for these following years, that is been settled by CO cell, by central office cell, and that order issued by Delhi should not be considered as a regional office, should be considered as a central office order. Prerequisite for compounding processor: prerequisite, no compounding for a similar contravention before expiry of 3 years. Post facto approval for RBI or GOE, concerned authority, or unwinding of transaction is must. Friends, it should not happen. मान लीजिए आपको किसी सेक्टर के अंदर प्रायर अप्रूवल गवर्नमेंट की लेनी थी, आपने ली नहीं, आपने कहा ठीक है आपके बात कोई प्रॉब्लम नहीं, किसी ने बताया है, अब जाके कंपाउंडिंग करा के खत्म करते हैं. आंसर इज नो. फर्स्ट यू नीड टू अनवाइंड दैट ट्रांजैक्शन, or you to go to government or RBI for seeking a post facto approval. Once the post facto approval, that means default has been made good, then only the compounding is been done. Compounding is the last stage. Firstly, you need to regularize the transaction. It is not the case in case you don't want to regularize and you want to go straight for a compounding, that is not permitted, friends. You must need to regularize by seeking a post facto approval. DOE, Enforcement Department of Enforcement, to compound relating to suspected money laundering, terror financing, affecting sovereignty and integrity, and non-payment of compounding rates within the timeline. Mind it, friends, whenever any proposal comes where there is a fear or there is a suspicion from the money laundering, terror financing affecting sovereignty and integrity of the country, those kind of matter cannot be compounded by Reserve Bank of India. Mandatory need to be referred to the ministry. So DOE. Always also you need to keep in mind, while you are applying for a compounding, you need to give an undertaking. There is no ED investigation or any other regulatory agency investigation is being carried out. If any matter is pending before ED, apart from these 3 areas, because which in any case is subject matter of the ED jurisdiction only, when you're filing the application, you need to make a mention. In that kind of case, RBI will accept, RBI is bound to accept your compounding application. Then they will refer the matter to Enforcement Directorate. And once they receive the feedback from the Enforcement Directorate to yes or no, they will act accordingly. Though RBI, as per our internal discussion in a number of cases, informally, not to be considered and seen as a Deloitte comment, practically in case RBI wait for a 30 days plus 15 days, maximum 48 days, 50 days. Then thereafter the officer in charge decide, RBI office decide whether we should compound or don't want to. By and large, if they believe matter is not of a severe grievance, then definitely they say, okay, we are compounding. Again, but in the compounding order, they still write without prejudice to the right of the enforcement director for which the proceedings are pending. Either of the scenario. If the Reserve Bank of India, if the enforcement director gives its NOC, even still, because proceedings of the enforcement director generally has not been concluded so fast. They say, this is a commit order which I am issuing under my power. Therefore, anything which ED may come up that need to be taken care additionally. But generally, I have seen practically, I have handled lots of handling ED cases. Once the matter has been settled, matter in question, or the court has been closed by Reserve Bank of India, Enforcement Director has no role to take that matter again and to impose a penalty again because that matter has already been settled by Reserve Bank of India. Therefore, this is a very fine game now. You need to be careful while you're advising a client for an ED matter. As a matter of practice, what you need to do whenever you're attending the ED proceedings, you can have a request with them. Look, guys, if it is a procedure and you believe there is no further investigation, matter is a procedure, left side sector has been there. They said, sir, allow me to go for an alternate remedy. Not in writing, but generally they accept it. You go, apply to Reserve Bank of India. When RBI send a NOC, observation review send a letter to the ED or DOE for their observation at that point of the issue NOC. That is the best way of settling it out. Once the ED is settled, we have done recently many cases, at least 9 or 10 cases in the last 6 month period of time I've done similar transaction. ED, bless this transaction, chapter over thereafter. 99.9% it's gone over. This is all you need to pay. Indicate to RBI the indicative factor to decide the compounding is gain or unfair advantage wherever quantifiable made as a result of the contravention. Loss cost to any authority or agency exchequer as a result of the contravention. Economic benefit accruing to the contravenor from the delayed compliance or compliances avoided. The repetitive nature of the contravention, the track record and the history of the non-compliance of the contravenor. Contravenor's conduct in undertaking the transaction and disclosure of the full fact in the application and subject and submission made during the personal hearing and any other factor as considered relevant by the appropriate. They need to keep all this factor in mind. Generally, they go by a matrix which has been provided. Hardly I've seen any case where actual 3 times of the penalty has been imposed. But always I've seen the cases where within the three times parameters, within the thermal boundary, RBI Act. Therefore, the process which you need to be followed, file an application along with the fees of 5,000 as a processing phase, as per the format prescribed by Reserve Bank of India. Generally mandatory document are MOA, latest audited financial affairs prescribed format, ECS mandate, other mandate, and action master direction undertaking from the undertaking. Security has been carried by Reserve Bank of India. Replying to the queries in case any query has been asked. Hearing by Reserve Bank of India. Hearing is always an optional. They generally send you a letter, though it is an optional. You have already, in case any additional fact you want to, you are more than welcome. Otherwise, if you want, we can go for an ex parte. Need not come to for hearing. It is an option. Because rule of natural justice, CPC needs to be followed. Therefore, they always are. Compounding fee shall be calculated in accordance with the matrix as per Reserve Bank, which is only an indicative method. And once it has been done, compounding order shall be issued. Compounding order shall be issued. And I must say, friends, from last so many years, I'm seeing one agency is definitely adhering to the timeline, commitment, or I must say, no hanky-panky ever take place in this Bank of India. Compounding order always been issued within the time limit prescribed, that is 180 days. Amount imposed can be up to 3 times of the amount involved. I have already discussed with you. Compounding fee to be paid within a period of 15 days from the date of compounding order. In case the failure to pay the compounding fees within the time specified, it shall be deemed that the contravenor had never made an application for compounding of any contravention. Friends, what is the effect of the order? Friends, as we stated, as we have seen, time-bound completion, no suo motu investigation, No further proceeding for contraveners. No request for withdrawal of the order funds made, sir. To hold the order is wide. No review to the order, sir. No appeal, no vakil, no dalil, sir. No appeal can be made against that. Sir, always keep in mind, sir, it is an order because it is appeal can lie only for a for litigation, not for a settlement issues. Payment of sum and contravention need to wait 15 days. Failure to make the payment applicable shall be returned. And if no application filed, as if the application has not been filed, and matter referred to DOE for adjudication. Though the withdrawal of application is possible before compounding order is permitted. We have seen number of cases when the compounding authority, when it comes to the compounding authority, if it is up to 40 lakh, AGM has the power. If GM 40 to 1 lakh crore, DGM has the power, and thereafter beyond that 1 crore, GM and CGM and above has the power. During the course of proceeding, you can always, if you believe you are not heading, or the things are not heading into the right direction, you can always tell we would like to withdraw the order. Simple send a request or email, we would like to withdraw the order. But the repercussion of the withdrawing of the order matter is bound to be referred to the investigation, because you have come to the investigate for the compounding. Believe me, RBI never direct you to go for a compounding. They simply say this is what has been contravened. There is a provision in section so and so, subsection so and so. You have a right to, you can come for that compounding. It is not a mandatory requirement because it is an optional thing. You want to get it compounded, you get it compounded and matter is over. And in case you file the application, compounding proceedings are been there, order has been issued, payment has been advised to be, compounding fees has been advised to be paid. You are not paying it, then it shall be returned back as if never filed. And since something has been there, that is why you are not paying the vendor. Therefore, that matter required adjudication. Adjudicating authorities only and only enforcement director. They are bound to refer the matter to enforcement directors. This is what the process you need to follow, not only in the FDI, ODI, or any kind of contravention under Foreign Exchange Management Act 1989. With this, I conclude my discussion, friends. Now the house is open for question answer. I would like to answer any of the query, friends.
Thank you, Atul sir. At the very right time, you have stopped the discussion. Approximately 30 questions have been received by the Secretariat from the participants. I would like to take up all the questions one by one at the time permit.
I will try my level best to answer. Yeah.
I think you are the most competent person to answer all these queries.
Let me try, sir.
The first question is, how can foreign universities offering courses in India go about complying with FEMA regulation in cases of having dedicated marketing practices? Who is allowed to collect money and who is not?
See, the fundamental issues of the AICTE regulation, education is still in India, though it has been opened way back from to certain extent has been open for the foreign university or education. But education again in India has been carried out by the trust or society, not by the company. There is a mechanism which has been there, trust and society is having in this particular business. They are investing into a service provider company. FDI can come only onto those companies, those are rendering services to those education so-called institute. And when it comes to Section 8 company or Section 8 company or trust society, of course, the money as an FDI cannot come into the trust, cannot come to a society, can come under Section 8 company after complying with these rules and regulation. If you're attracting, complying with it, that is permitted. But generally, I've seen education company, if they're bringing FDI, there is a very less chance, except the model which we guys are generally as a consultant advisor, only through those model this is allowed, but it is not as a free trade for, unlike in other industries.
Okay. The second question, what are the investments and activities specifically prohibited in the FEMA? I think you have already answered.
Already covered gambling, betting, speculation, PDRs, real estate, construction, tobacco product, railway and atomic energy.
The third query is, what are the additional conditions of ODI for financing sector under the law?
Financial service sector, they have divided into two parts. In case it is an NBFC, you need to take a prior permission from the NBFC Department of the Reserve Bank of India for making investment. If it is a CIC, registered CIC, definitely you have to take the permission. If it is unregistered, definitely again you have to take the permission. If it is into the insurance sector, you have to take the permission from the insurance, meaning thereby, in case their company is registered with the financial service sector, in order to have a registration as a company outside India or making investment outside India by way of company or branch office, you have to have the NOC from your service sector, from the sectoral regulator which is regulating.
Okay. The next query is, what is the round tripping and what role can professional play in this?
See, as far as round tripping is concerned, the situation came in the 2014 when it has been clarified. Indian companies making investment outside India. And thereafter that investment, when it has been made, by be the same amount or additional amount has been raised, and thereafter the money is coming to the country as an FDI. ODI FDI transaction is a round tripping, right? FDI can be existing already or can be after sending this money. In both the scenario, RBI consider it as a round tripping. The objective is why you want to route the money, why you want to bring the money sent from India are being taken. Why don't you make investment directly from India to India? Why it is bringing that causes always a question into their mind, causes a question in their mind. Therefore, they said this is not under automatic. I have taken hundreds of approvals, not hundreds, 15, 16 approvals for this prior approval from the RBI, explaining the reason why it is rational along with the rationale. However, recently they have allowed if it is a two-layered structure, 1 and 1, that is allowed. If it is multiple, no under automatic prior approval is required. Even if it is a scenario you have invested only $1 or $500, $5 billion has been made, you are bringing that. You can always say it is not a round trip. Answer is RBI concept is investment has been allowed to make bona fide business activity outside India.
Right.
That is the fundamental quote unquote point. As per Regulation 5, read with 13 has to be there. I am permitting you to take the money outside to carry out the business bona fide business activity outside India. If you are taking it out and again bringing it back, why you are bringing it back? They want to see that particular thing. That is why it is called round tripping.
So the professionals, right?
Professionals need to be fully aware of the rules and regulation, and they can say if it is a two-layered, it is allowed. If it is not, then and profession can always say 5 scenario. I can say direct money, indirect money. It could be a scenario when you are acquiring making investment in the overseas country, overseas company, that already having a FDI. Or once you send, thereafter they are bringing, because the penalty are being changed. Penalty are different. Penalty are different. If it is already existing, or if it is not. Those 5 or 6 judgments are there. You can discuss with me offline, because I luckily handle all these kind of cases. There are a number of other kind of things where you can say the penalty exposure could be. Why I'm telling you, penalty, if company already having, if ODI already having an FDI lag, or FDI lagging is coming subsequently, penal consequences are different. Penalties amounts are different. Once you are fully aware of those kind of situation, then you will be in a better position to advise your client, accordingly minimize the risk and the penalty.
This is what that professionals should be very cautious and very careful while dealing with the round trippings.
See, I always say, Dhananjay, whenever these kind of things come, be it is your client agree or don't agree, you need to carry out thorough due diligence.
Right.
This is one of the area. Rather than simply someone has hired me ready to pay me 2 lakh, 3 lakh, 5 lakh rupees for this case, you jump to the color, you prepare the application and file it. Once you file it, you get to know hundreds of other skeletons have been there. First, you carry out due diligence. The moment you carry out the due diligence, I'm telling you, it may be possible the client is coming to only for one work.
Right.
They may end up giving you 5 additional work, you point it out another 5 months. This is how you can do it. And you can do the smart work and ease your work also.
Right. The next query is, what are the various reportings and how can professionals support their clients? You have already answered this.
Already, that's we covered.
Okay. What is the core difference between ODI by RIs and LRS?
See, RIs and LRS is no difference. Whenever the resident individual is sending, there is a route maximum provided to 250,000 limit. That is the only thing we have to keep in mind. Anything which is going out of the country for the purpose of ODI by individual, 2 things you have to keep in mind. It can only be in the operating company. It cannot be an operating holding company. There is no, after example, Dhananjay invested in Singapore, one company, operating company. Dhananjay need to take the benefit from that company only as an operating company. If that Singapore company is further investing into other company, that is not allowed. That will Dhananjay be complying with it. That is the point you have to keep it in. And the limit of remittance, amount which can up to in a financial year, which Dhananjay can send, 250,000 financial year US dollar, not more than that.
So the next query has been sent by a gentleman. Please discuss about the TDS on foreign exchange spending by Indian directors on official trip abroad.
No, that is a current account transaction. Even if it is an official travel, now it has been subsumed all in the LRS limit. You can refer the circulars. Recently also it has been clarified.
Next query is, if subscriber capital of foreign subscriber is shaped subscribed capital of foreign subscriber received after 6 months, then issue of shares within 2 months or after receipt of capital. If issue of share capital within 2 months, then compounding is required or not for late receipt of capital. Kindly elaborate.
See. You need to refer the 56(2) of Companies Act. We say within a 2 month, you need to issue the share certificate to the subscriber. Right? FEMA provision says once you made the allotment, FEMA reporting comes into place only on allotment for issue of shares. Once you're issuing the shares, within 30 days, you need to submit Form FCGPR. Right? Within 60 days from the date of receipt of money, you need to issue the shares. A share certificate need to be within 30. Form FCGPR need to be submitted within 30 days. As long as you're meeting and maintaining these two things, no non-compliance has been there. If you are not, then you are non-compliant.
Okay. Next query, sir. If the company has received excess money of rupees 3 lakhs due to the fluctuation in foreign exchange
refund
account.
it back. Refund it back or convert this into capital, make allotment share, additional shares allotment.
Atul sir, the query is different. The person who has read this query is saying the company doesn't want to refund it. What is the way out?
You can allot the shares now after taking an approval from the Reserve Bank of India if 60 days period is expired. I was giving you both the answer complete. I was giving that you have stopped in between. Look, there are two options. Either you refund, you are saying you don't want to refund. If you don't want to refund, if it's still you have the 60 days window of original window within which you have to allot the shares. Allot those shares balance on account of this exchange fluctuation within 60 days. If the 60 days period has expired, seek a specific permission from the Reserve Bank of India, allotting after 60 days period of time. In both the scenario, if it is within 60 days, no permission, allot additional share. If the period has expired, seek the RBI approval for allotment.
So how a company can save itself from this exchange fluctuation things?
See, they cannot save. They cannot save. Bank charges, these are the two things which is always prevalent. Bank charges and exchange fluctuation. Exchange fluctuation is not in my hand. Because it is not the case you can receive in INR. It is not a trade transaction. Trade is permitted to receive in INR. The money has to come in the foreign exchange.
Right. So next query is, my company is an Indian company and we have project in Ethiopia.
No, sorry, 1 second. In some cases, we have KC INR. Indian bank is having it, then you can do it. But generally, people are reluctant to get in INR.
Okay. Somebody was suggesting that if you wish to receive 1 crore, it need to be reported to the foreign bank in the foreign party, and they will convert only 1 crore only on the date of valuation, and then they will send
amount is not been prescribed. That depends upon the bank to bank. RBI has not provided such kind of conditions. There is as per the board approval policy of banker is made there. But generally, they should overseas to overseas this kind of thing, or they send it through Vostro account.
Okay. Thank you. So the next query, my company is an Indian company and we have project in Ethiopia. Hence, we wish to receive $6 million in Ethiopian currency only beer. Will FEMA regulation apply to my company? Will RBI rules also apply?
Of course, sir. Of course, it will apply. You need to carry out with the current account transaction, trade transaction, export and import of goods and services, and the company joint venture or wholly owned subsidiary regulation, sir.
Okay. So the next query is, in case of buyback of share by Indian company from the foreign shareholder, the form FCTR does not have any option for the same. Which option to be selected while reporting?
It is clearly mentioned capital action buyback in the firm portal, boss.
The next query is, it is getting difficult to get FCGPR registered even. Invariably, the AD bank takes its own time to provide KYC and certified copy of FIRC in the manner prescribed. Time and again, CS certificates are required to be resubmitted. Such like difficulties are getting experienced. Please suggest way out as to how to handle such like issues.
Sir, I have seen practically 30 days period has been given. 30 days is very lengthy period which has been prescribed. Within a 1 week period of time, the moment remittance come, you are fully aware. In case you are a professional, a company secretary, you are fully aware. It is not something somebody has transferred the money online in your account without your knowledge. You have passed the resolutions. I have seen company secretary are doing really thorough job. Some of the company secretary, they know them on such and such, they pass the resolution. They keep track of when the money is coming. Before the money is hitting, they are ready, keeping their entire documents ready, right? Except dates have not been filled. The moment money hits in, they immediately report. They already have an intimation and discussion with the bankers. Look, this money is coming from such country as a FDI. This is the compliance requirement. This is FIRC requirement. Everything has been taken care of. If you are carefully planning, I can't agree if bankers are taking most of the time. If you are submitting your form on 25th, thereafter queries are bound to be raised, and thereafter you're submitting, right? Then it is not their fault, your fault. Within the time limit, with effective planning, you can achieve with strategically. It is not something which has been there. By and large, we have seen. I do agree. Sometimes bankers also are not being able to support you properly at that point of time. In case you have a sufficient support, they say on 15th, each and everything I have completed. Nothing has come. For unnecessary things are there. You should be patient enough. You settle it down within the period of 30 days. Even if after that you believe something has been left over, right? Then you can always approach to Reserve Bank of India for making complaint. This is what the case is.
Okay. When you talk about RBI approval, whether AD to be taken into consideration or it's only RBI?
No, sir. When we say RBI deal with through authorized dealer along with the recommendation information, except for compounding matter. Compounding is a matter between the party and the RBI.
The next query is, sir, the application for compounding of offence is invariably disposed of by the RBI in how much time? Could you please let us know?
180 days, I have already said. Within 180 days, RBI disposed this compounding application. They're bound to it, they're doing it also.
Okay. In case of NRI, is upfront payment of 25% applicable for warrants?
Of course. Sir.
What is the time generally taken by DPIIT for approvals on investment?
Anything between 6 months to 16 years, I can say.
Okay. It's a very big time.
And then I'm just saying, lightly I'm saying, because I haven't seen that generally taking 1 year period of time. That is why things are becoming, in my practical experience, becoming worse day by day. Though the SOP has been issued by government very warmly, 77 working days time. 77 working days time itself is becoming 90 days time. And I have never seen single approval in 7 year period of time, 8 year period of time, I would say in 77 days.
Next query, what is the time generally taken by RBI for disposing post facto application by companies involving matters like allotment of participative share, NRI investing through saving account?
See, fundamentally, all of us are professional. When I started my career, I was meeting with one officer in the government department. Manager revolution case, if you recall, Dhananjay Bhai used to be there, prior approval of government, etc. Right. I met one of the gentlemen, and luckily who was my friend also, who is also a company secretary, who remain registrar of company also, and who's still a registrar of company, OTP, at the Ahmedabad office. He taught me one thing. You need to help the officer to help you, not because of any other reason. It depends how robust your documentation, your supporting and the filing has been made. If your all documents are in place, by and large, though I know RBI don't have any specific checklist, but you need to think simple English and simple fact. What is your company? What do they do? Right? How this document has been filed, all supporting document. RBI doesn't generally. Of course, the additional queries are bound to be raised by Reserve Bank of India. I have seen generally within a 3 month period of time, 3 to 4 month period of time, they close the matter. Generally. Right. Sometimes I've seen they have handled so many cases where they conclude in 3 to 4 week period of time also. But for that, you have to be mindful for one thing. Seek an appointment, go there, meet them, get it confirmed what all document information you can. वो कहते हैं whenever निवेदन करके जाएंगे तो हर काम होएगा. As a ego, arrogancy, जाएंगे ये नहीं करता कंप्लेंट लेके जाओगे तो कंप्लेंट लेके ही आओगे साहब.
And I personally found RBI people very supportive, very professional in their.
Always been here. One agency which we can always proudly say is existing in India was providing good benefit, all welcoming you and giving you all solutions.
Right. The next query: in case the resident transfer had passed away, and it is identified that no FCTRS was filed, can the form be filed by non-resident transferee? Also, can he post filing the form file compounding application?
Yeah, of course. But for that, since there is no specific provision has been made for transmission cases by Reserve Bank of India, you have to approach to RBI for seeking approval specifically. Once the RBI approval has been granted, then notice can be carried out.
Okay. Next query: whether restricted list means prohibitory list also?
Yes.
Is there any pricing guidelines for ESOPs to be given to foreign employees?
No.
If railway operation in restricted area, then how can we expect bullet train project from Japan? Very
No,
good
no,
question.
they are saying, if you see the regulation, I said railway except railway transportation and support services. There is an exclusion list which isn't provided.
Okay. Good.
Yeah, sorry. Carry on.
The company doesn't have old FCGPR approvals for the sales allotted 23 years back during 99-2000. Now for allotting new sales, AD Bank is asking for proof of old FCGPR approvals.
General problem, go to RBI, CKS. First you approach to your authorized dealer bank, request for them. In case they are ready, they give you in writing, nothing is available, they cannot find out. Based on that letter, supporting approach to Reserve Bank of India, request them to give the photocopy from their file. Though this is not a legal rule. I shouldn't say legal, this is not legally required. RBI is not legally bound to consider that. But practically, I've seen if you approach them, if you have relationship, you have made good relations, they will be able to release it.
Okay. In case an NRI invest in a listed company, then will it raise a requirement to file FLA return?
Yes. Company is filing, na?
Okay. Next query is, can an Indian company accept loan from an Indian director from its NRO account, not following the ECB guidelines?
No, NRO account is not deposit because it would be treated as an NCD then.
Okay. If anyone opening IFSC company inside the GIFT city Ahmedabad, do they require the approval from the regulator for receiving the funds in the form of equity?
Let me tell you a quite interesting question. Recently, I handled 2 cases of the GIFT city, IFSCA. The OPI regulations have been applicable for that. If it is a financial service sector regulator, then you need to seek a specific approval from the financial service regulator to which your company pertains, and thereafter you can make an investment. And there is a reference also in case they do not respond. That means the RBI do not respond to the financial service sector regulator. Say RBI, IDA, PFRD, SEBI do not respond in 45 days. 45 days, it shall be considered they have no objection to make. Therefore, IFSCA registration is possible. If it is a sectoral, prior permission from them is required to be sought.
Okay. If a company is engaged in consultancy in real estate sector, is it a restricted activity?
Automatic. It is a service industry.
Okay. Thank you, Atul sir, for dealing with the subject in the most elaborative way, and it was wonderful to listen you on the FEMA after a long time. It was a pleasure for me also to listen to you. Probably we have missed the opportunity to meet each other in recent times, but it was a nice opportunity to see you virtually.
Always been.
Before I proceed for the vote of thanks, I would like to acknowledge the presence of Mr. Sandeep Agrawal, Sandeep Kejriwal ji, my Central Council colleague, and also Pawan Chandak ji, another Central Council colleagues who were present, in this webinar. Atul bhai, I extend my warm and deep, sincere gratitude to you for. I have received the other questions as well. Can we take up?
Yeah, please. Any question?
Bhuvan, time है ना अभी? अच्छा, हाँ, तो थोड़ा सा अभी vote of thanks को जो है वो करते हैं, defer करते हैं. I think we should take it up. हाँ. Can you explain recent amendment by RBI guidance? In fact, I have received all these questions just now only because. Okay. So can you explain recent amendment by RBI guidance under automatic route only if activity is legal in both the countries?
Legal?
Can you explain recent amendment by RBI guidance under automatic route only if activity is legal in both the countries? Even I am not able to comprehend the question.
No, I am not able to. I am not able to comprehend this question.
Okay. During incorporation in 2005, we had invested in our 100% WOS in Thailand. Partly paid up. Now, can we convert partly paid up into fully paid up by making capital infusion? Can the share certificate date is prior to our investment date?
See, each partly paid up investment, you need to brought the share certificate. In case those certificate has not been brought in past, you can brought it now. After reducing 6-month period of time, whatever the number of days delay would be there, that would be subject to penalty. Right.
Okay. If any NRI investing in CCPS of a startup company, do the company need to comply with FDI regulation? Is filing FCGPR needed in this case?
Of course.
Okay. Does a company need to file FLA return as per FEMA even if there is only one NRI shareholder holding one share on repatriable basis?
$1, $0.01.
Okay. What are the limits of compounding by ED and RBI?
I have already discussed maximum 3 times out of the amount involved in the transaction can be imposed by Reserve Bank of India. 2 lakh maximum can be imposed by Enforcement Directorate, 5,000 rupees per day, and subject to confiscation of the goods or services as the case may be, as well can also be resorted.
Okay. The next question is again on round tripping of funds, which you have already answered beautifully. The next query is, what shall be the provisions applicable for relocation by way of slump sale of a company to a foreign jurisdiction?
Nothing. It's a sale purchase transaction. It would be treated as a trade transaction as long as the BTA is there. Assets are being sold to them. Pricing is, though there is no pricing guideline, of course, the valuation has been assigned as per the valuer which has been there. That transaction need to be presented to the authorized dealer bank. If authorized dealer bank is satisfied, they will allow to receive or make the payment. If it is not, then they refer to the Reserve Bank of India for a specific approval. If they do so, then you need to approach to Reserve Bank of India through authorized dealer.
Any approval is required for issuance of equity shares of listed company for consideration other than cash by swap of shares to non-residents Indian?
No. Swap is been allowed as long as it is under the automatic route.
Okay. So when the company is required through IBC and new management takes over the company, the investment made by the company in unquoted foreign companies are impaired in financials. Whether it will still continue to be considered as ODI and how to deal with for filing FLA in such case?
FLA in any case, till the time even a single cent is existing, you need to file, because till the time, impairment is a process from accounting, and the board approval process need to go for the purpose of impairment and virtually writing of the losses, etc. investment, right? FLA does not, once this impairment is taking place in the balance sheet, do not have any foreign asset currency, then FLA can be stopped. And for the purpose of impairment, we have already discussed, if you say, the restructuring provision of the balance sheet, right? If it is percentage to the extent of their holding, you can get it. In case it is beyond that, prior approval of Reserve Bank of India or any condition of the automatic route has not been compliant, you need to seek an approval. Once the approval has been granted or impairment took place in terms of the restructuring automatic provision, thereafter you need not to, because balance sheet do not carry any kind of foreign asset.
Okay. Can foreign company in which resident individual invested money further invest in another foreign company?
I have already covered this by taking you as an example. Only operating company, not as an operating holding company.
Under the guise of ODI, by short selling, diabolically, someone makes profit, whether non-ethical or ethical, then is it difficult to find the person who has made profit rather than finding a scapegoat under the guise of ODI? If by short selling, diabolically, someone makes profit, whether non-ethical or ethical, then is it difficult? I think it is repetitive. Again, I am repeating it. Under the guise of ODI, if short selling, diabolically, someone
short selling and those kind of thing concept from the RBI perspective is not there. RBI is going to catch only the shareholder, the Indian investor. Okay. If something else has been taken, they will definitely bound to refer the matter to ED for investigation.
So by this, we have covered 40 questions during the span of 20-25 minutes, and we have answered each and every query very beautifully. I'm sure our participants have immensely benefited. अतुल भाई, मैं हमेशा इस बात को कहता हूं कि दीपक से दीपक जलता है, दीपक की यही सफलता है, और यही बात नॉलेज पे भी शामिल होती है कि knowledge always gets multiplied by sharing. And you have been doing this, as I said, for last 25 years. And it is always wonderful to listen to you in person, virtually on the FMA, which is your, subject, which upon which you have, high level of command. So I extend my deep and sincere gratitude to you for sparing your very precious time to be with us in this virtual webinar and sharing your very deep and, experienced knowledge with all the participants. I'm equally thankful to my president for allowing the CLDC committee to conceptualize this idea for this Master Knowledge Triple E and to start it with the session on the FDI. I'm equally, grateful to my council colleagues for approving the scheme, and equally grateful to the secretariat led by Deepaji. I'm thankful from the core of my heart to all the participants who took out time to, attend this webinar. I just want to make one announcement, that is, in this month, on 12th, we are covering CSR, 3 to 5. Mr. J. Sridhar, our past president and also the company secretary of, Bajaj Auto Limited, will be our guest speaker. Then on 19th, we'll be covering the RPT, and on 26th, we'll be covering the SEBI LODR. So I have requested Sudhakar Sasutala ji, Sudhakar ji, and Ravi Verma to come and deliberate on different topics. So we are going to organize on 12th, 19th, and 26th. So I have announced already three webinars of this month. And in times to come, as I said, for the sake of the repetition, again I am repeating it, that we'll be organizing every Wednesday 3 to 5. So my humble and polite request to all the participants of this seminar, be there and take out benefit of our experiences speakers like Atul Bhai on different subjects, and our endeavor will continue in future also. Atul Bhai, once again a very deep
Thank
and
you to
sincere
all. Thanks a
gratitude.
lot.
बहुत बहुत धन्यवाद, आप आए, आपने इतना बढ़िया सबको अपना नॉलेज जो है शेयर किया, और आगे भी आपका सानिध्य हमको मिले, हम ऐसी उम्मीद करते हैं। आईसीआईसीआई के साथ आपका स्नेह बना रहे। बहुत
Thank
बहुत
you very
आभार।
much for the participation.
Thank you
By
so
you and
much.
Manish.
So with this we conclude this webinar. Thanks to all.